Mr. Biow, Chuan.
So I declare my interest in speaking on this topic as a practicing lawyer and whose area of practice includes landlord and tenancy-related matters. I've acted for both landlords and tenants. In principle, sir, I agree on the need for fair and more balanced lease negotiations between landlord and tenants of retail premises. This is especially so when tenants have spent tens of thousands of dollars renovating their premises and establishing their businesses at the rented premise. Often, there is goodwill built up by tenants in respect of a particular location. So this bill makes it mandatory for landlord and tenant to comply with a set of code of conduct for the leasing of retail premises which are defined as qualifying leases. The Code of Conduct was drawn up and issued on 26th of March 2021 by the Fair Tenancy Pro Tem Committee. So I've read through the Code of Conduct and in particular the leasing principles stated in the Code of Conduct. First, I agree with this principle that a landlord should act reasonably and not have the power to predetermine the lease of a premise unless there is a requirement for redevelopment works. And if the landlord does predetermine the lease due to redevelopment works, then it is only right that the landlord should make some offer of compensation to the tenant for the cost of renovations incurred. However, sir, I want to express some caution when Parliament is asked to legislate on matters which ought to be determined by market forces. This was a similar principle made by Minister Indrani Raja in February 2018 when she responded to my colleague, the Honourable Mr. Murali Pillai, during his adjournment motion. She said, in general, free market principles should apply. So I'm also concerned that the Code of Conduct is not a subsidiary legislation drawn up by the Attorney General's chambers, but by a Fair Tenancy Industry Committee who has the right to propose modifications to the Code of Conduct. Although members of the Fair Tenancy Industry Committee is appointed by the Minister, in the event that one day more members of this FTIC are pro-tenants, then there's a risk that the recommendations in the Code of Conduct may tilt too much towards protection of a tenant who is not the owner of the property. So allow me to set the context of landlord-tenancy relationship in perspective. Landlords are typically owners of properties and they have paid hundreds of thousands or millions of dollars to buy real estate. These property owners are then part with possession of the premises to tenants who are given exclusive possession of the premises for the duration of the tenancy. And in many landlord-tenancy disputes, the greatest worry of the landlord is that they are unable to recover possession of the premises from a tenant in default of renter. By the time the landlord commences legal action to seek an order of possession, the arrears will have accumulated to a large amount. Hence, the starting point for most tenancy agreements is that they seek to protect the landlord, to enable the landlord to recover possession of the premises whenever there is a breach of tenancy agreement. Many of us in this House may not remember the Control of Rent Act, except Mr. Murali, which was legislated after World War II to protect tenants against unscrupulous landlords during housing shortage in the post-war years. However, eventually the Control of Rent Act was abolished, and this was because it outlived its purpose as there was no longer a housing shortage. Further, at that point of time, rent-controlled tenants had demanded exorbitant compensation before agreeing to vacate the rent-controlled premises. And so I've acted for such tenants before the Tenants Compensation Board. I know how difficult it is when the tenant demands hundreds of thousands of dollars for a premise that he does not own and for which he has been paying a small, meager sum of rental for many years. Thus, I call on the government to review any request for amendments to the Code of Conduct with some caution, so that a right balance of fairness can be considered from both the landlord and the tenant's point of view. During times when there's a shortage of retail space, usually landlords have a better bargaining position. And we have had a relatively strong economy for many years and property prices have remained strong. However, during times when there is a glut of retail space, tenants can and will make demands for better tenancy terms from the landlord. Landlords will then cut rental. They will moderate their tenancy terms in order to rent out their premises. Otherwise, a vacant premise is deemed to be a wasting resource to the tenant, to the landlord. If there are many retail properties which are vacant, it may cause property prices to nosedive. Members of this House who have lived through the Asia financial crisis in 1997 will know that a negative property market may eventually result in a recession because property owners cannot pay for their loan installments, and many property owners face financial ruin. In fact, observers of the retail market will also know that not all retail space are in equal demand. There are some shopping malls where there are still many empty retail space as compared to a major shopping mall where there's huge demand for retail space due to better management of the mall. Thus, sir, I would urge that we should consider allowing free market principles to set tenancy terms as far as possible. In respect of the bill, I have a few queries for the Minister of State. Paragraph 3 of the Code of Conduct provides for advertising and promotion charge to be kept at overall gross rent. This means that if a landlord wants to adjust what is commonly known as the A&P charge, advertising and promotion charge, he must do so within the total gross rent payable by the tenant. But surely A&P charges payable by a tenant should be a matter of negotiation between landlord and tenant. As long as it can be proven by the landlord that the A&P charge are meant to promote the mall or the building, why does the Code of Conduct restricts the amount of A&P charge to be collected? The setting of this rule will cause a landlord to simply refuse to conduct any advertising or promotional activities for the building or the mall if he is unable to raise A&P charges without cutting back on the amount of rental that he receives. So if the total amount of rent cannot be changed, then he will simply not do any A&P activities, because why would he want to cut his own rental? Paragraph 4 of the Code of Conduct also provides for the landlord to pay compensation if there's predetermination of the lease. As said earlier, I agree with this principle, and I will add that we should make it mandatory for the landlord to send reminders to the tenant on the need to submit their declaration of the value of capex works within 3 months of completion of the renovation works. And this is to avoid a situation where a tenant may have forgotten to keep or to submit records of their capex and thus be unable to substantiate their claim in the event that the landlord does predetermine the tenancy. Next, sir, I want to speak about Clause 2 of the bill. Clause 2 of the bill provides for the law to be applied to all qualifying lease. So may I ask whether this would include even the smaller retail landlords, like those in HDB shops, or the owners of smaller shops at Lucky Plaza, City Plaza, or Peninsula Plaza? How does the government intend to assist the smaller landlords to ensure that they are aware of the need to comply with the Code of Conduct? For example, would they be aware of the need to provide a certificate from the registered surveyor or the cap on the amount of security deposit? I know many of these small landlords who have absolutely no clue where to find a registered surveyor because they've been renting out the place for so many years. Next, Part 4 of the bill requires the landlord or tenant to settle disputes with an authorized dispute resolution body. And that authorized dispute resolution body must then maintain a panel of mediators and a panel of adjudicators. May I ask Minister of State, which is the authorized dispute resolution body? So I declare that I've served as a director in the Financial Industry Dispute Resolution Center, FIDREC, for 12 years. And I know for these past 12 years, it's not easy to establish a dispute resolution body which has a pool of experienced and respected adjudicators and mediators. So would this body referred to in this bill be able to find enough adjudicators who are sufficiently experienced in landlord-tenancy disputes? Finally, Clause 26 of the bill requires parties to a settlement agreement to apply to record the settlement agreement as an order of court. What if one party refuses to consent to the recording of the settlement agreement? Who then will bear the legal cost of filing the application to record the settlement agreement? So I'll be grateful if the Minister can assist to clarify my concerns, and say for those concerns, I support the bill.